A question that has come up all throughout this case is now starting to come up multiple times a day. And I'm getting tired of writing it over and over again. So I'm just going to do a video and then I'm going to pin it. And you can just go back and reference it anytime that you want to. And the issue is, why does it matter what Wayfarer or Friedman or Perez Hilton or any other content creator was doing after Blake Lively filed her complaint in December of 2024? Isn't the retaliation claim about what happened before she filed the complaint in August of 2024? And the answer to that question is that as of right now, Blake Lively has claimed in her complaint that number one, the smear campaign that began in August 2024 is continuing to this day. And number two, that the defamation claim they have against Wayfarer by and through Brian Friedman's statements continues to this day. So she has alleged in her second amended complaint that that harm is ongoing. Now, people get upset with that and say, yeah, but once she filed her complaint, doesn't Wayfarer have a right to defend themselves? And the answer to that is yes. There is an argument that after the complaint was filed, what was happening was not retaliation, but self-defense, and that there needs to be some stopping point for when it stopped being retaliation, as she's alleged, to the extent there ever was any, and began becoming just people defending themselves in a lawsuit, both inside of the court and outside in the public domain. But the reason that we still don't know exactly the answer to that question is because the judge has not been asked to make that division yet. He has not been asked through a motion to dismiss or any other kind of motion to say the stuff that happened after the CRD complaint was filed cannot possibly be retaliation because it is litigation privilege or attorney-client privilege or some other First Amendment right to defend oneself in public from a public lawsuit in a New York Times article. All of that information is out there, but it has not been teed up as a legal ruling in the case. So the judge has not ruled on it because he hasn't been asked. So what you're seeing is that issue coming out in little pieces through the discovery disputes, right? No, we're not going to give you anything that comes after this date because we're going to take the position that what happened in March of 2025 isn't relevant to the retaliation claim. And then Lively says, yes, it is, because we're claiming the retaliation is ongoing. And so you're seeing it in these micro disputes all throughout discovery. But what has not happened yet is the judge saying, okay, I am once and for all going to make the decision that anything that happened after January or after December 20th of 2024 is not part of the retaliation campaign because there is no way to prove that it was caused by retaliatory motives when we all know that it was caused by people defending themselves against a huge public accusation. Now, I do suspect that Wayfarer will address this at the summary judgment stage. I fully suspect that they are going to file a motion for summary judgment trying to get rid of the defamation claim on some grounds and also to create a barrier to say there has to be some end to the retaliation campaign claims, and here's what it is. But that has not happened yet. And one of the things that I think is really frustrating for people to understand is that judges do things when they are asked. This judge has 200 cases. He doesn't go through and go, what legal issues can I find? That is the job of the lawyers. That is why Lively and Baldoni are spending tens of thousands of dollars a week on lawyers to tee these issues up. And so when that issue gets teed up, I do think that there is a strong legal argument to say that what Wayfarer / Friedman / everybody / content creators did in response to this case being filed is a different liability question than what happened in August of 2024. So you're right to think about it that way. But in the case itself, that issue has not been raised yet. We haven't gotten to it yet. And that's why when discovery is sought for things that have happened over the last 7 months, these are highly disputed matters because they're having that argument on a very small level over and over and over and over again. So the big picture is discovery is guided by what is alleged in the complaint. And what is alleged in the complaint is that this stuff is still ongoing and it didn't stop the day that she dropped her complaint. And for whatever strategic reason, Wayfarer chose not to file motions to dismiss based on those grounds. And I'm sure they have their reasons, right? There is this case that's been cited before, the Leah McSweeney Bravo case, where part of her claim was dismissed at the motion to dismiss stage against Bravo. The claim that was based on retaliation for her lawyer sending a letter. And I think it was Judge Lyman in that case said, lawyers communicating on behalf of their clients about threatened or actual litigation cannot be retaliation. So that law is out there. But for whatever reason, Wayfarer made the strategic decision not to do that at that point. Maybe they felt like, you know what, let's just let all this information come out because there's not going to be anything before and there's not going to be anything after. And if we let all the discovery happen, that way they won't be able to later say, well, we couldn't find out what happened after the case was filed because they blocked us from discovery, right? Maybe they're like, let's just let all the facts fall where they may. We'll deal with each discovery issue as it comes up. But they have made that decision. So as frustrating as it can be, to feel like, why does all of this matter? Everyone in this case, Lively in her complaint and Wayfarer and how it's responded, has chosen to make this part of discovery for now. So I hope that that makes sense. I know it's not a satisfying answer, but this is why I'm trying to slowly teach about what summary judgment looks like, because summary judgment exists for exactly this kind of purpose. To raise a legal issue to say, once and for all, can it be retaliatory if it is in direct defense of a federal lawsuit? That's the place where you make those arguments, but you cannot make those arguments until all of discovery is done. And we are getting close, but we're not quite there yet.